This is Eye on Bankruptcy, brought to you by the American Bankruptcy Institute.
Welcome to the December episode of Eye on Bankruptcy, a monthly discussion and analysis of recent cases and developments in the bankruptcy world produced by the American Bankruptcy Institute. This program will give you 1 hour of CLE credit in states where it is pre-approved. My name is Charles Tabb. I am the Mildred Van Voorhis Jones Chair in Law at the University of Illinois College of Law, and also am of counsel with the law firm of Foley & Lardner LLP in Chicago. I am your host for Eye on Bankruptcy. We're very fortunate today to welcome two distinguished guests. First, the Honorable Ashley Chan, United States Bankruptcy Judge for the Eastern District of Pennsylvania, and second, Russ Silberglied, a director of the law firm of Richards, Leighton & Finger in Wilmington, Delaware. Judge Chan sits as a bankruptcy judge in Philadelphia. Prior to taking the bench in 2014, Judge Chan was a shareholder at Hangley, Aronchik, Siegel, and concentrated her practice in the areas of bankruptcy and corporate restructuring. She earned her bachelor's and law degrees from Rutgers University. From 1996 to 1997, Judge Chan served as law clerk for the Honorable Gloria M. Burns, the United States Bankruptcy Court for the District of New Jersey. She also served as chair of the Eastern District of Pennsylvania Bankruptcy Conference. Russ Silberglied is the director of the law firm of Richards, Leighton & Finger in Wilmington, Delaware. Russ earned his BS with honors from Cornell University and his JD from Penn. Russ practices both bankruptcy litigation and core Chapter 11 work, including breach of fiduciary duty suits, equitable subordination, recharacterization litigation, first and second lien litigation, valuation fights, and contested plan confirmation and DIP financing. Thanks to you both for joining us today. Today we will be discussing 7 cases which we have taken from Rochelle's Daily Wire, available on www.abi.org. If you are keeping track, our discussion today will cover the following topics and cases drawn from the Rochelle Daily Wire from the following dates. First, we'll talk about tuition payments by insolvent parents as fraudulent transfers. The case of Pergament v. Brooklyn Law School, decided on November 27th and written up by Bill on December 3rd. Secondly, we'll talk about dueling super priorities. That is, who wins when Section 364C1 and 726B collide. This is the Happy Jacks Petroleum case out of the Bankruptcy Court in Nebraska from November 7th, which Rochelle discussed on November 15th. Third question, it has to do with the dischargeability of student loans being arbitrated. The Roth case out of the Southern District of Indiana, which was in Rochelle on November 27th. Our fourth issue has to do with allowing post-petition contractual attorney's fees on unsecured claims out of the Everlasting Tribune Media case, Delaware decision in late November, which Rochelle talked about on November 28th. We will talk about what happens with the post-petition appreciation of a home with regard to its exempt status, a Ninth Circuit decision of Wilson v. Rigby, discussed on November 29th. We will discuss a case arising out of the Madoff case, whether avoiding powers, and specifically the recovery, has extraterritorial effect or not. In this case, as we'll discuss, Judge Rakoff had held no, but on appeal to the Second Circuit, Rochelle's reading, which he discussed on November 26th, is that perhaps the Second Circuit's primed to reverse. And we will talk about the always fascinating issue of the effect of rejection of leases. In particular, we're going to focus on 365H, a case out of the Revel casino case in which the tenant, as it worked out, was able to stay rent-free. And that's on the December 4th discussion. So, our first topic, which we believe is of interest to and will likely terrify parents, children, universities, law schools, is the question of whether when a tuition payment is made by an insolvent parent, it constitutes a fraudulent transfer. This is the Pergament versus Brooklyn Law School case. Basically, what happened in this case, Daddy, who's bad daddy, had 3 adult children in college or law school. We could feel some sympathy for him, I guess. He was insolvent, which happens to you when you get a judgment of $11 million rendered against you. Subsequently, he made payments totaling over $250,000 for the kids' tuition to various schools. Schools, of course, know nothing about Daddy's unfortunate financial status. All they know is they're getting tuition payments. So certainly the school is at least acting in good faith. That's not really even contested. After Daddy files bankruptcy, the trustee sues the schools to recover all the tuition payments made on behalf of the kids at a time when Daddy was insolvent. So, Russ, we're going to ask you to take the lead on this topic. I guess the obvious first question is, why would these tuition payments even potentially be avoidable fraudulent transfers in the first place?
So obviously we're talking about constructive fraudulent transfers here. We're not talking about actual fraud, or at least the court didn't analyze it that way, and there are no facts that we know of to talk about it. So the question is whether or not there was reasonably equivalent value given by the father for his kid's education. And of course the education was not provided to the father himself, it was provided to the kids. So the court was analyzing it as there being no value given to the father himself. Now, that could be a very debatable proposition, and in fact there are some other cases that say at least where the student was a minor, that there is reasonably equivalent value given. We could also make value judgments as to whether even when they're not a minor, whether that should be the case. But that's why the court was discussing it that way.
And they didn't even mention it, right? They didn't even mention value at all. They just presumed that there was no reasonably equivalent value given in this case.
Well, in regarding that, I mean, some of our viewers may be wondering, well, what about the safe harbor of 548C? I mean, school, kids enrolled in school, there's kids getting an education, they're getting tuition. Why aren't they protected? So why are they not protected by 548C?
We have a couple, and first of all, the court analyzed this entirely under 550, not under 548C.
And why do they do that?
We have a couple of issues under 548C. You've got services being provided over time. They're being provided over time, not to the person making the payment, but to the student. And you're providing something that is intangible in nature. So 548C has got some issues in trying to apply to this type of transaction.
So when you're getting paid by Daddy for the kids' tuition, you have a problem of what value you're providing to the debtor, to Daddy.
To the debtor himself, yes.
So what then, Russ, if you're in the position of the school, if we establish that it is a fraudulent transfer, and of course in fraudulent transfer litigation, I always tell my students 2 questions. Is it a fraudulent transfer? And then from whom, if anyone, can you recover? And usually in these cases, number 2 is the sticking point. If 548C won't work to save them, what is the only ray of hope left for the schools? And what was obviously the operative issue in this case?
So from the school standpoint, the question is going to be whether they can assert the good faith defense in Section 550. But what that's going to turn on is, in 550 itself, it says that there is a distinction between an initial transferee and subsequent transferees.
So you want to be a 550A2 subsequent transferee. You do not want to be a 550A1 initial transferee. If you're an initial transferee, what's your status?
If you're an initial transferee, then you've got a problem. And so,
do you have any defenses, or do you just have to hand it over at that point?
Well, I mean, again, so we're talking about this in terms of Section 550. As the judge was saying, there's some interesting issues about whether it should have been avoidable in the first place under 548. There's some other case law that we can be arguing about there.
But there's, there's no good faith defense if you're the initial transferee. So it's really, you want to be.
It's essentially strict liability.
Right.
Unless you can convince a court that it really was reasonably equivalent value, which
So
was an issue not.
But if you've lost under 548C, if you are even getting to the 550 game, if you're classified as an initial transferee, you're out of luck.
That's correct.
So the whole game in this opinion was initial versus subsequent transferee. Okay, in this case, Daddy sent the checks to the schools. That being the case, how can they not be the initial transferees? He sent them a check. They're the payee.
So the interesting thing is that, according to the opinions, the facts were precisely the same at each of the three educational institutions, which itself is interesting. You would think that maybe the different schools would set it up differently. But apparently the facts were that there was a student account for each specific student. The money would be funded into that account initially, and then upon registration, it would be moved from that student account into the general funds for the educational institution itself.
So they would get paid at that point. So in the bankruptcy court, this defense, so obviously the schools are saying, we are not initial transferees. We're subsequent transferees. Look at those kids. We're not the initial transferees. We don't want to be strictly liable. In the bankruptcy court, did that plea work?
Yes, in the bankruptcy court.
And why? I mean, how did they?
Because the bankruptcy court focused in on the fact that at any point in time prior to when the students registered for classes, they were entitled to a refund. They did not have to register for classes. They could have chosen, instead of registering for classes, you know what? I think instead I'm going to travel in Europe this semester.
Take the money and run.
They could have taken the money and run, and while they may have had a moral obligation to give the money back to Dad,
They'll at least have to talk to Dad.
they may have been very well advised to talk to Dad. There was no legal obligation to give the money back to Dad, and so as a result, they could have kept the money. And so the words mere conduit get used.
And so when the judge on appeal from the bankruptcy court reverses, what's the reasoning there?
Because there is a timing distinction,
Right.
and the judge reversed and remanded for factual findings of this
And
factual issue.
what's the key factual issue? And why does it matter?
Was the student actually registered at the time or not? Because if the student was actually registered and then the money came in, then the educational institution was permitted to take down the money immediately, and there was no refund permissible.
So they would be, so just make sure I understand, the school would be the initial transferee in the situation where this occurred post-registration.
Yes.
But if it occurred pre-registration, then they could be a subsequent transferee.
That's
and would
correct.
then have 550A2 potentially availing to them. So if you were, what is the takeaway? If this reasoning is correct, if you were counsel to a university and saying, you probably don't want to have tuition monies that you're paid be recovered some years later by some mean bankruptcy trustee, how would you structure the payment regime to enhance as much as possible the chances that you will prevail and that you will be welcome to the blessed safe harbor of 550A2 instead of being relegated to the harsh reality of 550A1?
You need to make sure that the student, that there is already payment into the student account before the student registers for classes. So if I were giving this advice, I would say set up some kind of automated system upon registration that does not allow the student to register for classes. It will kick them out of the system if they attempt to register for classes if there's no money already in the account.
And so that way, so I understand, Daddy has transferred the money effectively to the kids.
To the kids.
And then the kids are transferring. They're not the insolvent debtor. They're transferring to the university. So the university can say, not our problem.
Not our problem. Now, obviously, that also creates a risk for the educational institution, I suppose, that you're incentivizing the kids who have control over the money to do something else other than go to college that semester. but we would have to assume that that's not going to happen all that frequently.
Right.
Did it surprise you that that a child who's registered at a school that that they actually have access to that money? Do you think that I would never have realized that a student, and you have a student in college, did you know that your student could, your son or daughter could take that money and just cash it out and say, I'm not going to register for classes this semester. I'm going to go around the world. Did it surprise you to learn that?
Thought never crossed my mind.
Right. I mean,
And he's certainly not going to tell his kid.
That's right. I mean, another way the schools could structure it right is the schools could say, we don't want the money from the parents. We want the money directly from the kids. So you should take the money, parent, and put it in your kid's bank account, and then have your kid transfer the money directly to us. Then you run in. Then maybe everyone's more on board. They understand. The kid now knows I've got $40,000 in my bank account,
So,
and I could go for a trip around the world.
Set it up. See, you're saying, Judge Sheehan, set it up where a school says, we do not
We don't want the money
parents'
from the
money.
parent. We want the money from the kid.
We
Right.
want the money from the kids. So you guys work
Right.
it out.
And
Whoever
the
you want.
interesting thing about that is that probably a significantly higher percentage of students would be insolvent than their parents. On the one hand, on
the value,
on
they're
the right, on
they're
the other
getting the
hand,
service.
the reasonably equivalent
That's
value
right.
is going directly to the student.
And so they would be covered. Speaking of students, this opinion sort of leaves open very clearly the idea, well, just sue the student. What about that? What do you...
Yeah, so before I directly answer the question, I will say that we may be inclined to be rooting in this case itself for the educational institution because we don't like the result, but to the extent that the educational institution gets to say I was the subsequent transferee, the implication of that is that that means that the student is the initial transferee and the student's got a problem if a trustee would sue. Well, lo and behold,
And even if they're not the initial transferee, they're the for whose benefit.
or they're for whose benefit. So for all you avid readers of Rochelle's Daily Wire, when he wrote this up, he actually asked, would society countenance anybody suing the student? The next day after Rochelle's Wire,
Countenancing happened, huh?
an opinion hit where a trustee did exactly that. The trustee actually sued two daughters, wanting the money back from the daughters. As I understand it from the case, it's the Oberlin College case. So apparently Oberlin itself was sued but had settled, and the trustee continued to pursue the daughters. That case turned on how old the daughters were.
Okay.
With the court deciding that if the daughters were under 21, then the parent was providing an education for minors, although I'm not sure why 21 would be the cutoff for minors, and so that was not a fraudulent transfer, but several of those payments, the daughters were over 21 years old, and a motion to dismiss by the daughters was denied to the extent that they were over 21 years old, so the daughters have a problem.
Well, I think there's a practical problem here too, which is that colleges and universities have deep pockets. Students who are just at the outset of their careers don't have any money, so
They do not.
you can have a judgment, but what are you going to do? I mean, it's going to be hard to collect, I think.
Just sort of stepping back, final question on this before we turn to the fun of dueling super priorities. Is this a good idea? I mean, should we have universities being sued for tuition money? Should we have kids being sued? I mean, should there be a safe harbor? Should it be legislatively created? I mean, reading these cases, it just made me reminisce about the cases back before the church contribution safe harbor was put in, where trustees started suing churches when insolvent debtors would tithe. Do we want this going on? What do y'all think? And should there be a safe harbor? Can judges cook one up? Or
Well,
is the legislature going to have to tee it up?
Yeah, I don't know that I don't know that courts can cook that up themselves. I think that would be for the legislature. They did do something for religious organizations. That is a little bit different. Those are nonprofit organizations. I mean, most schools are set up as nonprofit organizations. There's a lot of money that's flowing through those schools. Look, I don't believe that it is a great idea from society's standpoint to be able to sue these schools. I think it's an even worse idea for you to be able to sue the students themselves. But I will say, in my personal view, before we get carried away with exemptions upon exemptions upon exemptions, that you also first ought to look at the overall scheme. Because I'm not sure that I would favor being able to go after small businesses, but not being able to go after large educational institutions. To me, it should be, either or both. You get to do both or neither.
Okay.
From my
Judge, what do you
perspective, I'm sympathetic. I think that
To whom?
I'm sympathetic to the universities here and to the students themselves. But for the universities, I would have liked to have seen some analysis of value here, and there simply was none. And I think that if this case was before me, I would certainly take into consideration the value. And frankly, the only time I'd be interested in avoiding a tuition payment like this is if you could prove to me, for instance, that there was actual fraud, such as if the student was, independently wealthy, had money themselves, the parents never paid tuition in the past, suddenly when they get smacked with a big judgment, all of a sudden
why
they're
don't you
volunteering
pay?
to do it. That's right. When there are
Okay.
badges of fraud, I think that that's an appropriate use of 548. But I think in most situations, I think parents paying their tuition is something that's value that we should all recognize, in my personal opinion.
The next case we have raises a very interesting and puzzling question having to do with dueling super priorities. The situation where you have initially a case under Chapter 11. In the Chapter 11, there's a 364C1 super priority granted. But then it converts to 7. Of course, in 7 we have the burial expenses super priority of 726B. And this is sort of a ubiquitous issue in bankruptcy. I mean, there's always the problem in bankruptcy that there's not enough money. And so Congress creates priorities. And then sometimes say, well, that's not a good enough priority, so we're going to have a super priority. Well, in this case, we have super priority versus super priority. So we get to see which one wins in that situation. And this came up in the Happy Jacks petroleum case. There have been a number of cases before it that raised the issue. And these cases are divided in that situation. I mean, the facts in this case were just very classic. You had this supplier, Handsome Petroleum, that said in the 11, we're not shipping on credit unless we get a super priority. 364C1 is the coin of the realm. We're going to insist on that. They get that. Case still fails, converts to 7. In the 7, they say, okay, pay us. And everybody objects. Says, well, we can't pay you because there's a conversion. Now we're in 726B. So we have to look at the dueling sections here. So, Judge Chan, I mean, the first thing that is important here, and the way that these cases often come out, is we have the courts looking very closely at the operative language. Much as I hate to read language, I think in this situation, for our viewers, it's probably helpful. I'll just go ahead and put it on the table and we'll let you analyze it. 364C1 says the court, upon the required showing, may authorize the obtaining of credit of the incurring of debt, 1, with priority over any or all administrative expenses of the kind specified 503, blah, blah, blah. Then in 726B it says, generally you pay administrative expenses the same, but it says, except in a case that has been converted to this chapter, blah, 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 a claim allowed under Section 503B of this title, incurred under this chapter, 7, after such conversion has priority over a claim allowed under Section 503B of this title, incurred under another chapter of this title. So this is the colloquial that the Chapter 7 burial expenses beat the pre-conversion expenses. Obvious problem, we have dueling incentives, right? We have the 364C1. Someone like Hanson says, we're not going to extend credit unless we know we're getting paid first. Okay, we're going to pay you first. But then it converts, and any professional or trustee or anyone would want to work on the case says, well, I won't work on it unless I get first. Okay, we'll pay you first. So in this case, Judge, who did the bankruptcy judge side with, and sort of what was their reading?
Well, the court sided with the super priority claimant. I don't know if I want to say administrative claimant, but in my head I would consider
You
it to
can't.
be
If
a
you say
super
that, then you've
I know
undermined
where
the entire
I know
reasoning of the
where
court.
your bias lies, and I think that unfortunately here, the language is unfortunately unambiguous. You've got 726, which only talks about Section 503B claims. That's the only section that they talk about. They don't talk about Section 364(1), so there's no mention of super priority claims. So I think that the judge clearly, was in her rights by saying 726 does not apply to 364 at all because it's not mentioned. So whatever priority scheme is in there.
Making that So what was the judge's crucial assumption about the nature or
I'm
of
gonna
a
get to that point.
364C1 claim, or perhaps I say what not is the nature of a 364C1?
The problem is that 726 doesn't talk about 503B, and 364 does talk about 503B. So the judge, because 726 didn't apply to 364, you fall back on the 364C1 language, which specifically says my claim has priority over 503B claims. So they win the day.
But was it necessary for the judge's decision to basically reason that a 364C1 claim is not an administrative expense claim? Because if it is an administrative expense claim, then doesn't 726B clearly say post-conversion beats pre-conversion?
Well, I think that when we all think about administrative claims, we think about Section 503B administrative claims. And if you had asked me before this, 364C1 super priority claims feels like an administrative claim. That's what it feels like. That's what it acts like.
Because it is.
Right, but the language in there is, first of all, it doesn't say with priority over any or all other administrative claims, right? If it said that, then I could see your argument.
Yeah.
But the problem here is that it's not mentioned at all in 726. It's not.
Right, and even more, keep going with the words you were reading, of the kind specified, so it's very specific of which kinds it mean.
So even though 364A and B, it talks about people extending credit on administrative priority, and then it says in C, in 364C1, and if even that's not enough, then you get a super priority. But now it's not an administrative expense claim, so there's no requirement that you comply with any of the administrative expense requirements that the courts have laid down about benefit to the estate or anything else. It's just its own separate
The problem is
creature.
726B doesn't mention 364 at all. It doesn't say it at all. So how can you possibly say that 726 would?
Well, the way you would get it, I guess, is by saying that a 364C1 claim is in itself also an administrative expense
Okay,
character.
but that's reading into the statute quite a bit. Show me the language in 726B which would give you that hook. It only talks about 503B. Where are you going to find that?
Well, the point is the characterization of a 364C1
That's kind of soft.
claim.
We're courts of equity. Don't get me wrong, but I can only push it so far. And I get what you're saying. I think that it feels.
But there have
like
been other decisions that said the statute clearly comes out the other way because they said obviously a 364C1 claim is an administrative expense, and so the plain language. This is why I talk to my students, and it's why it's always so fun to talk about the late Justice Scalia on this ground. It's like you get dueling plain meaning readings
I think that
from the court.
if you're a bankruptcy practitioner, you would think 364C1 is an administrative claim. That's the way we treat it. We would think that. But if you're not a bankruptcy practitioner, if you're a judge on a higher court, you're going to look at 726 and you're going to say, well, that doesn't mention the section, so it's not an administrative claim. You're not going to get it.
If this case is right, and as I said, there haven't been a lot of cases like this, but it is there is some split in the courts. What happens when you convert? If you have a situation where you've had Hanson Petroleum gets a 364C1 and the amount they're owed is more than whatever's left in the estate, it converts to 7. How's the 7 going to happen?
Well, I think that, number one, we were talking before, and I think that you see this a lot in your practice, but you're not going to see people getting 364C1 claims. You're going to see them getting some security, right? So, I don't...
So there's a bit of an oddity here, just noting that you already have the problem if everything's secured. If it's taken to security, then there's already nothing.
I just think that this is not going to be a common problem because most people are going to demand security. They're not going to rely upon a super priority administrative claim. They're going to demand security, which, so it's rare that you're going to see a 364C1 claimant in the situation where there's going to be a conversion and then you got it,
Let me ask you this question, Judge. Would you if this reading is correct, would you grant a 364C1 without a carve-out because you're essentially saying that the burial is, it sounds bad to say the burial is dead before it happens, but anyway, that 7's just not going to work, right? And so you're going to say to Hanson Petroleum, we're going to do this. Well, gosh, I won't do that for you. But of course, then you would have them saying, fine, we're not going to extend any credit to you, and good luck with that Chapter 11 case. So how do we resolve this?
This case gives me pause as a judge. I would certainly look look to the necessity of granting this type of super priority claim with the understanding that if there is a conversion someday, that may really hurt administrative claimants in that case. But I think that it's not going to happen that often. And as we were discussing before, at the time that the 364 claim comes up, you're desperate. You're doing everything you can to try and keep the case, reorganized. So,
Exactly.
right, you're not looking down the path to say, well, in a conversion, because you don't even want to contemplate a conversion. You want
We
them
won't even get
reorganized.
to that. And Russ, I know you've dealt with this type of thing, a lot of dip financing, things like that. What do you see as sort of we always have the fun, like legal statutory parsing, but we also have practical reality intruding. Tell us about the intrusion of practical reality here.
So, like the judge was saying, it's at least 99% of cases of post-petition financing will be dip financing, i.e. financing with a lien. So we're talking about the vast minority of cases as it is.
Yes.
If, as debtor's counsel, you are able to line up unsecured financing, that is great.
Which is already
for the,
miraculous.
right.
Yes.
It's great for the estate, and if you are to be able to have the slim possibility of being able to line that up, you could at least say, I'm going to grant you a super priority claim. If no matter what happens, I'm going to give you a super priority claim. If this case came out the other way and you were to take that away,
They can't believe you.
they would then say,
Unless it
okay,
converts to 7, in which case we lose. So the potential, like the Hanson Petroleum, they're like, well, so we're not going to do that because if it converts to 7 and 726B wins, we're going to lose in that. So we can't do that. We can't take that risk. That's what you're
right.
Right.
That's exactly right. And I will also say, I'm not sure I agree with your statement that this already buries a Chapter 7 case because it depends on the numbers, right?
Mm-hmm.
What if it's a case with $5 million of post-petition financing, which you're going to grant 364C priority to, and maybe they think that they have $50 million of fraudulent transfer claims because of things that happened pre-petition. You very well might have a trustee that is willing
willing to
be
roll the
behind.
dice.
I think your
Sure.
point, though, is that you never would have thought about that you'd have to take that into consideration going into a Chapter 7. You would have just thought, oh, our expenses, administrative expenses, will take priority over the Chapter 11. But
Right.
you can't automatically think that.
Exactly.
Right, but I will say, most cases that convert, the trustee already has to deal with that in the form of dealing with a lien
Yeah.
that is in
Yeah.
front of it, and so
Right.
this is a super priority
It
claim
is.
in front of it
And then we
instead.
end up, as we've discussed, I mean, you have negotiations, you have carve-outs, and things like that. Well, let's go back to talking about students and the always fun and terrifying student loan dischargeability debate, which in the Roth case versus Butler University, case out of Southern District of Indiana, the question on the table, one that courts are greatly divided on, is if there's an arbitration agreement in the student loan contract, and then the student, as Matthew Roth did here, in bankruptcy files an action under 523A8 to try and get the student loan discharged, arguing it's not an educational loan, undue hardship, and so forth. To which the lender says, "Why, my goodness, there's an arbitration agreement which requires everything to be arbitrated," and that's what happened in this case. Now, what you then have is we have to look at the Supreme Court cases on this. Judge Chan, go back to you. It's interesting. There's a couple of Supreme Court cases, and one of the apparently important issues here is what are the tests going on? So tell us about, we had the Epic, that's a great name, the Epic case, the less exciting name of McMahon from 30-some years ago. What are those Supreme Court cases? What were the tests there? And sort of how would those apply in this context?
Well, the McMahon test was the first decision that came down, and that was a more flexible approach. There, in order to determine, the Supreme Court held that the Arbitrations Act mandate may be overridden by a contrary congressional command, and in order to determine whether a contrary congressional command exists, they looked at, number one, the statute's text, or two, the statute's legislative history, or three, the more common one, an inherent conflict between arbitration and the statute's underlying purpose. So that gave the bankruptcy courts
So that's
a
going to be
more
the key.
easy- yes.
So what you're saying is under the McMahon test, and this will be very relevant, as we'll discuss in a moment. In this case, if you can show that enforcing the agreement to arbitrate would create an inherent conflict with the core purpose of this other federal statute, you can say, never mind, we're not going to enforce the agreement
That's
to
right.
arbitrate. Epic
subsequently came along.
Like in 2018, subsequently.
Yeah, right. And that test was a lot harder. In Epic, the Supreme Court considered a conflict between the FFA on the one hand, the FAA on the one hand, and the FLSA and NLRA on the other hand, and held that the party asserting a conflict bears a heaving burden of showing a clearly expressed congressional intention that such results should follow, and that the language must be clear and manifest in order for
Clear
the
and manifest contrary language.
Which is impossible.
So in other words, the federal statute has to say, and by the way, this means even if there's an agreement to arbitrate. This trumps arbitration. We're saying it right here it's in the United States Code, right here. It says.
I don't know where in the code I could find something.
Yeah, I think that would be
a
null search.
That's
yes,
right. That's right.
Congress never thought about doing anything. Whereas one can hypothesize that they would go as would happen in this case. Okay, so very critical question that this case had to address, any of the cases now are having to address, is post-Epic. Because let me ask it this way. If Epic has overruled McMahon, if McMahon is no longer good law, so forget inherent conflict, you have to have clearly expressed legislative consent, what's going to be the outcome in these student loan dischargeability cases?
You're going to be able to arbitrate.
You're going to be able to arbitrate. Why?
Because I'm not going to be able to find you any clear and manifest language in the bankruptcy code that's going to allow you to override that. So we're stuck with it. But as you mentioned, Epic, I don't know if it did not overrule. I mean, on one hand, Epic mentioned McMahon, and there is no case that you could point me to that says that that McMahon's no longer good law.
Which is what the judge in this court
that's
did.
Right.
This case.
That's right. So, but I'm not really sure how you can reconcile them, even though it's.
Which is interesting, right?
That's right.
Because it seems.
I'm not sure how you can put the two together.
But what the judge in this case did then is they said, based as you were just saying, said, I don't see anything in Epic that overruled McMahon. They even said kind words about McMahon. They didn't scoff at McMahon and say, what were they thinking back in 1987? So we still want to rely upon
McMahon. We still want to rely upon McMahon.
So this judge says, well, even if there's not an clear and manifest expressed intent, okay, that would be Epic, but we still have McMahon. All I need is an inherent conflict. The judge then proceeds to analyze the inherent conflict between arbitrating student loan discharge and the bankruptcy code.
That's right.
And how do they come out and why?
Well, Judge Graham first said that there was no appellate court that had found that either the text of the Bankruptcy Code or its legislative history suggests that Congress intended to have the Bankruptcy Code override the FAA. So we knew that they were going to lose under that. So he jumps to the inherent conflict.
So he's got to play the McMahon game.
He has to play the McMahon game,
right.
But he decides that before getting to the inherent conflict, he talks about some other cases, some circuit court cases, like Anderson, where those courts said that bankruptcy courts have the discretion to decline arbitration if the matter is a core proceeding and arbitration would frustrate or conflict with the purposes of the Bankruptcy Code, and also noted that the Third Circuit in Mintz did not focus on core versus core, but instead whether the matter was a statutory right under the Bankruptcy Code. He then identified the two issues at subject here, which was one, whether Ross' loan with Sallie Mae is a qualified educational loan under Section 523A8, and number two, if so, whether such loan may be discharged as an undue hardship under 523A8, and concluded that the issue of dischargeability is a core proceeding, thereby satisfying Anderson and his progeny. And he also found that both of these issues are included in the text of the Bankruptcy Code, which satisfies Mintz. So
one of the conflicts is this whole idea of fresh start. Like what's one of the most important things in the bankruptcy case? Fresh start. When do you lose fresh start? Like if you don't discharge your debts. So we're saying we don't want some arbitrator sitting here deciding on the fresh start for this person. And then second fresh pillar, the conflict is said, and we want these things generally centralized in the bankruptcy form. This is a bankruptcy topic. Bankruptcy judges know bankruptcy. They should be playing the game.
That's right. Once it was decided that the bankruptcy courts had the discretion to decide this, then they got into the whether or not there was this inherent conflict, and they looked at both those pillars that you just mentioned. And I mean, dischargeability is the name of the game. That's why you filed a bankruptcy in the first place. So I think trying to imagine this issue going to arbitration. I mean, 523, it's a very specific beast. All those 523A provisions are very specific, and we're familiar with them. But to imagine an arbitrator understanding that, it's...
Not. And it's interesting, Bill Rochelle in his Daily Wire even talked about, said, if it comes out the other way, why not also for claims allowance? I mean,
Right,
if you have
there's no limit.
there would be no limit, and so we have effectively decentralized that.
The one other point that I
Yes.
wanted to make is that you can't assign away your bankruptcy rights. We all
Essentially.
know that you can't assign away your right to file a bankruptcy. So how would you be? What's the justification
You
for
can't waive the
allowing us to-
discharge in advance.
Exactly. Why are we allowed to arbitrate then? What's the basis for that?
Yeah, just because we love arbitration.
Well,
Arbitration's great.
yes.
So the next topic is one that is extremely important. It's one that sort of at first blush you think, well, is that right? That can't be right. The question is, Russ, and this comes out of the Tribune Media case, post-petition attorney's fees that are contracted for in an unsecured claim, are those or are those not allowable? And that, I mean, in the Tribune Media, it was like an indentured trustee. I mean, the post-petition attorney's fees were like $30 million. There's a lot of money riding on this. Goes up, Judge Carey, a very carefully reasoned opinion, looked at a lot of different reasons, which I know you'll talk about no, this is not allowed. You cannot recover that. But then goes up on appeal to the district court, maybe comes out the other way. Now, whenever we're talking about this kind of situation, we have to first grapple with the very odd, puzzling, confusing 2007 Supreme Court opinion in the Travelers case. So just to get us started, first just kind of give us a little heads up on what Travelers was talking about, and then why that matters for a case like this.
So Travelers was also a post-petition attorney's fees case.
Right.
Slightly different type of contractual arrangement than this one, but I don't think that matters really to this issue at all. It came out of the Ninth Circuit, and the Ninth Circuit historically had a case called Phobian. And
The infamous Phobian rule.
so the Phobian rule that had been developed by the Ninth Circuit was that you couldn't get post-petition attorney's fees specifically if those fees related to bankruptcy issues. That went up on cert to the U.S. Supreme Court. The parties attempted to argue more broadly about attorney's fees generally, and the Supreme Court rejected that procedural play. So it very narrowly held that the Phobian rule was overruled, that there was no basis in the bankruptcy code, that Phobian was simply judge-made law, and that it was overruled.
Which it was.
But took some of the very issues that Travelers and other cases, other Second Circuit, Seventh Circuit, other circuits had talked about, described the issue, and then said, we're not ruling on this.
And so they said, all we're saying is no Phobian. You
No
can't
Phobian.
have it say. So now there may be, and Judge Carey relied on this, said there may be other principles of bankruptcy law that would mandate the disallowance of the claim. So talk a little bit about this. First, like Judge Carey, what the bases he had for saying no go, not going to allow it. But then, of course, it gets reversed. And the district court obviously says, well, I like the other side better.
Sure.
What are the operative issues?
And let me just say, before I get into the operative issues, this isn't just Judge Carey and Judge Andrews. So there are numerous cases across the country that have dealt with this, both before Travelers and after Travelers, obviously outside the Ninth Circuit where they were applying Phobian. So many cases, and as Judge Andrews' opinion pointed out, some have come out either way, albeit all of the circuit courts have come out the way Judge Andrews said, and not the way Judge Carey did. The arguments, while Judge Carey spelled out four, there are really two main ones. The two main ones are an implication from Section 506 and also a portion of 502B. So taking those two in turn, 506, obviously 506 deals with secured claims, not with unsecured claims. And so you might say to yourself, well, why are we dealing with 506 secured claims if this is an unsecured right to attorney's fees? And the reason why is that under 506, it's pretty clear that you're only entitled to a secured claim for attorney's fees if you are an oversecured creditor. So there's a split for oversecured creditors versus undersecured creditors. If you're oversecured, you get a secured claim for attorney's fees. If you are undersecured, you are not. And so,
Because it says so specifically.
yes, and that specific argument was addressed by the United States Supreme Court and then said, but we're not going to rule on the issue.
Right.
So that was one of the two, and Judge Carey
And so
came
what
down,
they do then, you're saying they basically say, they essentially draw a negative inference from 506 and
Negative
say, well,
inference.
if an undersecured creditor can't get it, surely a completely unsecured, that would be crazy. Or stated otherwise, only an oversecured creditor can clearly get this. So if you're completely unsecured, you're obviously out of luck.
the reason for the little chuckle was that I would have called it exactly what you did, which was an inference, but apparently to the Supreme Court it argued that it wasn't an inference, but instead it was an express negation. I'm not
Even
sure,
stronger.
but the Supreme Court didn't take that up.
Right.
But whether you're calling it a negation or an inference, either way, yes, that is one argument.
And it was persuasive to Judge Carey.
It was persuasive to Judge Carey.
And the district judge, without much reason, just said disagree. But that's one of the issues that's always going to be on the table. What was the other one? You referred to 502.
Yes, the other issue is that the exact words of 502 is that the court must, quote, determine the amount of such claim, and now I'll ellipse for a second, as of the date of the filing of the petition, and allow it in such amount. So the point is that if we're talking about post-petition attorney's fees, no amount has accrued, quote, as of the date of the filing of the petition,
Because the
end quote.
services haven't been
Been rendered.
performed yet, and it's really hard to have a claim for services you haven't rendered
Correct.
yet.
Now, like I said, so that was Judge Carey's opinion, and he primarily rested on those two grounds. He mentioned a couple of others, which I think are a little less important to today. The district court here, Judge Andrews, really only addressed one of the two, albeit he did cite other Circuit Court of Appeal opinions that addressed the other one. So dealing with them in order that we just talked about it, well, before we do, Judge Andrews came at it from the standpoint of he wanted to cite the specific words that were used in Travelers, and the specific words were, quote, claims are enforceable under applicable state law and will be allowed in bankruptcy law unless they are expressly disallowed. And so what he said is he doesn't see anything in that 506 argument that we just laid out before that was express. I'd like to add...
And he didn't think that 502, where it says the amount on the petition date, was express enough to say
Right.
post-petition.
Well, let's get
is
back
not-
to 502 in a minute, but let's keep talking about 506 and the express. While it doesn't say this specifically in Judge Andrews' opinion, I do think that one way you could look at this is to say 506 does not say that an undersecured creditor can't have an unsecured claim for attorney's fees.
Fair enough.
It says that you can't have a secured claim for attorney's fees. And if that's the case, then I'm not really sure it is, whether it's an implication or what have you. With respect to the 502 argument, as of the date of the petition, again, Judge Andrews doesn't address it, but for example, the Second Circuit case, Ogle versus Fidelity, that case did expressly address it, and it said, as of the petition date, you have, if you have an attorney's fees provision in a pre-petition contract, you have an allowed contingent unliquidated claim for attorney's fees. So you already have that claim. It is an allowable or an allowed claim.
In an
It is
amount of
simply
what?
in an amount of unliquidated, but it will become
Which would be
liquidated.
zero because
At
no
the time of
service had
filing,
been
it's
performed.
zero. At the time of filing, it's a zero.
Well, at the time of filing, it is unliquidated, which
It's zero.
not according to the Second Circuit.
Everybody gets one wrong sometimes.
Well, I don't know. I mean, there are many instances under the code, obviously, where your claim becomes liquidated post bankruptcy. And I do want to add to this that while it's not even an Ogle, there is an interesting way of looking at this if you contrast it to Section 502b2, right? So 502b2 is an exception to the general rule that says that you cannot get an unsecured claim for unmatured interest.
Right.
So if you think about it this way, the starting point in 502b says that you get your claim allowed unless.
Right.
And B2 is unless it's unmatured interest.
And so
if
you're
it
basically
weren't for-
drawing an inference from that to say
Correct.
that other things that might accrue after.
Correct. So interest would have been allowed if it wasn't exempted, even though it hadn't matured on the petition date. And so because there's no exception for attorney's fees, I think that you can take an implication out of that.
Final thought of this before we move on to a couple of the other cases. If this is good law, this gives a clear advantage to contract claimants over tort claimants. Right?
Or certain types of contract claimants. Because
Well, I mean,
not-
ones that have
Provisions.
people
for
that have like
attorney's fees.
trust indentures where they write
Yes.
careful contracts, they have smart lawyers drafting their contracts. They're going to get $30 million in post-petition attorney's fees. No chance for tort claimants getting post-petition attorney's fees, right?
That's true other than the 30 million, right? That's a unique fact of this case. It is not typical in even in the largest of large bankruptcy cases that the indenture trustee
Right.
puts in a post-petition claim for $30 million of fees.
They just had a lot of work that needed to happen. Let's talk about interesting problem out of the. Quickly talk about the curious effect of 365H. And after we do that, then we'll go back to the Madoff extraterritorial effect, and then we'll finish, time permitting, with the discussion of post-petition appreciation and exemptions. So, Judge Chan, in the case of the Rebel Casino, it's always a problem, right, when contracts releases get rejected. And obviously, there's a lot of debate about the effects of rejection stuff. But some situations, Congress felt like the unfairness to the non-debtor party was sufficiently severe enough that they put in a special protective rule. One of those situations is where the debtor is the lessor, rejects a lease of real property. The poor non-debtor tenant is like, well, now what? Now what do we do? Congress said, we feel sorry for you. Here's 365H. Okay, what does 365H give said poor non-debtor party tenant looking at a rejected lease by the debtor? And how did that then play out to their benefit in the Rebel case?
Well, 365H1A little 2I says that when a bankrupt landlord rejects a tenant's lease, the tenant may retain its rights under such lease, including rights related to the amount and timing of payment of rent and other amounts payable by the tenant, and any right of use, possession, quiet enjoyment, subletting assignment for the remaining term of the lease. So that's what you get. You can stay there. You don't have to leave just because your landlord says, I've filed for bankruptcy and I reject your lease. You can stay there, but you got to pay your rent.
But they didn't have to pay rent, and this is what the sort of the nice catch line in Rochelle's Daily Wire is: you can stay rent-free.
Well,
how they that's sweet. They got to stay rent-free.
We were talking about this beforehand, and I think that these are very unusual circumstances. This is not something that tenants should
What
be
was it
getting
about their
really
lease that was so special?
Basically, this was the Revel. They were building it out. There were 3 venues
Yep.
that they were trying to make profitable. So during the first 4 years, if the venues were not going to be profitable, the landlord was basically going to offset the rent to make sure that they, stayed even.
So no rent owed until we're profitable. And so what the judge was able to say is that lease term kicks in, you're able to take advantage. You get to say, because obviously they're bankrupt, they're not turning a profit, you can do that. Judge also, last thought about this case, didn't just go on 365H, also invoke the doctrine of equitable recoupment. Tell us about that.
Well, equitable recoupment is also something that they. Sorry, I didn't realize we were going to jump that far. I just want to say also at the beginning that don't feel too sorry for the for the buyer here, because as Bill Rochelle pointed out, that it cost $2.4 billion to build the Revel, and the buyer bought it for a mere $82 million. So
that's a big discount.
It's a huge discount. So I don't feel very sympathetic at this point with the buyer here. Okay, so
But so recoupment, I mean, when you have recoupment, right, sort of out of the same transaction, you sort of have these,
And it's
I mean,
not-
it's like super offsets, offset out of the same
Right.
transaction.
it's not in the bankruptcy code. This is something that's
Just
that's
an
done through
you said
decisional
your
law.
courts of
Right.
equity.
So in order to recoup, both debts must arise out of a single integrated transaction, so that it would be inequitable for the debtor to enjoy the benefits of that transaction without also meeting its obligations.
And so here they said that applied.
The one other point I wanted
Yes.
to add that I think at this point it was clear in the 363 sale order that
That's
those
very important.
365 rights were specific. They were carved out. So any buyer
Specifically
who
referenced
read
it.
that should have said, "I got to read the lease. What am I on the hook for?"
Right.
And then I think
Exactly.
that puts everyone on notice what's going on here.
What's going on. Let's shift gears and talk about a big issue, and looking at Rochelle's State of the Art. It sounds like the Second Circuit may be looking to address this. They recently held oral argument out of the Madoff case, which is the extraterritorial effect. I mean, as many of you know, one of the big things that was happening in Madoff is you had Madoff transferring money to these feeder funds, lots of feeder funds, many of which are insolvent in their own jurisdictions or under administration proceedings or whatever, transfers to them, obviously burning, committing a massive fraud. Then those feeder funds making transfers to investors. What's on the table in this case is the Madoff trustee suing not the feeder funds, but the investors in the feeder funds who have raised a defense under 550 in basically saying you can't get at us because it doesn't apply extraterritorially. It's like we're a foreign investor in a foreign feeder fund. Like, U.S., stay away. So this in the district court, what was the holding there with regard to the issues? What are the specific? There's really three sets of issues that come up, Russ. And what was the holding by Judge Rakoff on those?
So Judge Rakoff dismissed. Judge Rakoff.
So he held in favor of the foreign investors in the feeder funds, saying, you're right, you're foreign, we won't be mean and apply the U.S. law to you.
Colloquially speaking, yes, indeed. So he dismissed. He was not going to apply Section 550 extraterritorially. So we're back to the very first thing that we talked about,
Yes.
which is this dichotomy between Section 548 and 550.
Right.
And we'll see as this discussion goes that the Second Circuit may have viewed it as 548 rather than 550. But specifically, Judge Rakoff said, I'm going to break this down into three sub-issues.
Right.
And the three sub-issues are, first, is this an attempt to apply a law extraterritorially or
At all.
isn't it?
Yeah, okay.
Second, if it is one, does Congress allow me to do that?
In a situation, but for example, just to interject, in 541, it's quite clear, right? Because they say wherever located.
Wherever located.
Meaning like on the globe.
Yeah, I mean,
or
obviously,
outside of the globe.
one, I suppose one logically could say wherever located meant wherever located in the U.S. if you just
But
didn't
courts
believe.
clearly
Right,
believe that,
correct.
even if it's extraterritorial, that property of the state.
Correct.
Okay.
So
and
541, the
so
law
is
is
it applied
established.
extraterritorially? If so, is there an express statement by Congress? We understand they meant it. Whether you can or not, I mean, sovereignty has its unfortunate restrictions and limits, but anyway, such is life. Then, even if so, what's the final lurking issue?
Whether or not the court should not weigh in on the issue and should dismiss, stay its hand, whatever you want to refer to it, under the doctrine of comity.
And the idea there being that there's just the expectation, the foreign interest, and so forth. This is not really appropriate to deal with that. So the ultimate outcome, Judge Rakoff said, is an attempt to apply extraterritorially, not a clear expression of intent, and we think comity would apply. It seems, and we're running low on time, but it seems that the Second Circuit panel, at least Bill's take on it, that they might be ready to reverse, potentially. What were they looking at?
It does, although I want to specify two things before
Yes.
I do it. Number one, all of Rochelle's comments were of one judge of a three-judge panel.
Right.
So obviously, one judge is
Could end up being
minority
2-1
of
the
three.
other way.
We don't know how it's
Most
going to
vocal
come out.
judge.
It was clearly the most vocal judge. Also, the three of us have not had access to the transcript, so we're going by what's been reported. But based upon that, it certainly seemed that at least the one judge wants to reverse. He made a couple of comments. First of all, he, with respect to which statute between 548 or 550 was the key one to look at, he said that it was clearly 548 because the key issue was that the fraud itself occurred in the United States.
So you focus on the fraud, not on the recovery.
Focusing on the fraud, not on the recovery, and that certainly is true, that the fraud itself came from Madoff. He also looked at, 548 uses some language that looks like it ties in the words from 541. 550 does not use those words. So if you're looking at this as what I'll call 548 centric,
so you can tap into that wherever located hook.
Correct. So if you're looking at this as 548 centric instead of 550 centric, then you might say it's not the precise words, but they're similar. And with respect to whether the U.S. has an interest, he seemed to be focused on the fact that the investors in Madoff securities, while Mr. Madoff has recovered a lot of money already, they are still not even close to whole. I believe that the amount that came up was $6 billion.
Yeah.
$6 billion shortfall still. 13.3 billion recovered, which is pretty impressive, but $6 billion shortfall still.
So this is obviously going to be a very important decision, and when it comes down, depending on how it comes out, it could potentially be a circuit split, which could go to the Supreme Court. Well, we're basically out of time. We did have, and I recommend to viewers that they go back and look at the Wilson v. Rigby case out of the Ninth Circuit discussed in the Daily Wire on November 29th, which deals with exemptions as applied to post-petition appreciation. And the punchline, if you're wondering, is bad news for the debtor in that decision. She did not get the benefit of that.
Do we want to just point out that one last point of that?
Of course.
Okay. So I think the last point we wanted to say was, the history of the actual bankruptcy case is that this debtor did not get her discharge. Independently, the trustee had found that she had fraudulently transferred assets and had not reported that. So
there was a lurking.
Then
She wasn't being
the
a good
bankruptcy
girl.
judge's opinion,
Yeah.
maybe the majority's
Judges
opinion.
are human, and that
Yes.
could happen.
Yes.
But those of you that do have a consumer practice, I would strongly encourage you to read Wilson v. Rigby, particularly if you practice in the Ninth Circuit. Meanwhile, in conclusion, thank you to Russ Silberglied, Judge Ashley
Thanks
Chan,
for inviting me.
for joining us on the December Eye on Bankruptcy. Thank you.